Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I'm very excited to bring to you today attorney Timothy Stickradt of HS&A law firm out of Detroit. They are a bankruptcy law firm. And today we're going to clear up some of your questions that you might have about what really is the process of bankruptcy. What happens with bankruptcy? Are there any facts that you need to know going into it that might surprise you? Really want to take the mystery out of it, because it's not as crazy as some people might think, never having gone through it. So I want to thank you so much for joining us today, Tim, and welcome to the show.
Well, thanks, Erica. Nice to see you again. I hope you had a great Mother's Day.
Oh, thanks so much. I did. And you were telling me that you had a really special day planned for your wife with your kids. And I loved some of the ideas that you had. Will you want to share a couple of those before we get started?
Well, yeah, the beauty is one of my 6.5-year-old daughters decided that we should make breakfast in bed for mom. So I did. But they did a great job. They made little cards for her and made jewelry and necklaces and things, and she really loved it. So we had a great day.
Oh, that's really great. That's good. So yeah, that's fantastic. And so now we're gonna talk about business, and we're gonna talk about what happens with bankruptcy. Now, bankruptcy is often thought of as a bad word and something people should be ashamed of. But I mean, one of the things we start off with is that it's not something to be ashamed of. And I mean, I don't know, what is your opinion on that? Do you find that that's the reaction to some people when they start considering this option?
Yeah, I do. I think that people are embarrassed or maybe ashamed, maybe too proud to consider bankruptcy. And I think it all goes back to bankruptcy's just gotten a bad rap over the years. I think some people view it as admitting failure, when in reality, I think it's acknowledging that you need to do this for success. Bankruptcy should be looked at as a tool, okay? Just merely a tool to help you get out of a bad spot. Nothing more than that, nothing less than that. You got to understand that the bad things that caused you to consider bankruptcy, that's the real problem. Those things have already happened. So to go forward in life, you've got to fix those problems. And when I talk to someone about a bankruptcy, once we've got their situation understood, we go through all the possible options, including bankruptcy. Not everybody files bankruptcy. Not everybody needs to. Sometimes it's okay just to talk to someone about it and decide not to do it, or maybe there's a better option out there for you. But you should always get your options and be open-minded about it, because I think if you do, you'll find that's the best way and the fastest way to get yourself into a better spot again.
Absolutely. And one of the things I want to mention while we're on this topic is how you work with people, especially now. I mean, we're doing this interview during kind of a strange time, although people may watch this later on and wonder what the heck we're talking about. But this is during the COVID-19 crisis. So just wanted to mention to everybody that you are open for business, and the meetings with you are painless, and you don't judge, and so they should not worry about coming in and talking to you, and they can still talk to you right now during this COVID-19 crisis. The courts are open. A lot of things are being done virtually. You are meeting with clients virtually and able to answer all their questions and work just as smoothly as if we were not in the middle of this pandemic.
Yeah, that's true. And in some cases, even smoother than before we were in the pandemic, believe it or not. We are meeting with clients virtually. We're doing all of our client intake calls over the phone or over a Zoom meeting. Even the court hearings are being done that way now. So at this moment in time, one could consult with an attorney, file a bankruptcy, get a discharge, and get back on their way to financial success without leaving their home. So it has become a lot easier during this crisis for someone to actually file. All document exchanges now can be done through email or actual mail. We're not letting clients into the building yet because we're restricted on that, but we're allowing people to come to the building and drop things through the mail slot if necessary. If they don't have, access to a fax machine, or they're not good technologically speaking with email. So if you've got a problem and an issue with something like that, we'll help you solve that problem, but it can be done no matter what.
That is really great to know. And I also want to mention before we move on with this is that one of the things I feel like people can expect when they meet with you, there's a first meeting. We're going to talk about what that entails. But in addition to not having to feel embarrassed about their situation, you guys are just very down to earth. Everybody there at your law firm is intelligent. You've worked in the courts for many, many years as a team, and you have all the answers, and you'll go through all of their options for their specific situation. I mean, a lot of times people come in and they have a feeling of what should happen because of maybe what they saw on TV or something that they heard their neighbor had to go through when they went through bankruptcy, or a family member. But really, it's a meeting that is specific to their situation. And I'd love for you to just kind of give us a rundown on what happens in that first meeting after they call and make an appointment, just to get an overview on what you can do for them.
Sure. And we have been doing this for a long time. I've been doing bankruptcy law for 22 years now. My partner, also my wife, about 21 years now. So we've done this a few times. We've been around the block. But yeah, we also, I don't want people to, I like people to come in open-minded when possible. I know sometimes, we've talked to a friend or maybe a family member, or maybe we've seen something on TV. It's important to remember, though, that everyone's situation is different. Even if at a glance it seems like it's the same, it really isn't. Every situation has to be looked at independently and reviewed objectively. So your situation is different than the next person. The person who told you to come here, their situation was different than yours. So, it's important that we follow all the steps each and every time. What would I do is when someone wants to come in, first of all, the initial consult is free. The person would come into my office. We would greet them. They would come in. We'd escort them to the conference room, and you'd offer them, a beverage, a coffee or a Coke or a water, whatever they might want. There's a little form that I have people fill out with just their basic information, their names, their phone numbers, their addresses, email address, job, title, employer, and then a few additional questions. It takes about 3 or 4 minutes to fill that out. Once that's done, typically my case manager, Jennifer, will go into the room with them first. And she'll sit down with them and just get into more detail about their situation in terms of what types of debts they have, which debts are causing the problems, what assets they have. Do they own a house, a car? Are they leasing a car? Are they working? Are they retired? Are they unemployed? What expenses do they have? All the financially relevant stuff, so we can get the picture together. And then Jennifer will come and talk to me, and we'll go over, that stuff in detail. She'll explain the situation to me, and Jen and I consult for about 5 minutes. And then sometimes another bankruptcy consultant, Lawrence, will come in, and the 3 of us will talk about the case. And we'll basically come up with a quick overview and a basic plan. And then we'll go back into the conference room to meet with the client. And I like to always let the client tell me their story first. I don't want to rush into anything. I mean, we've got time when we're in there. I generally know the situation at this point because Jennifer's explained it to me, and I have her notes in front of me. But I always want to hear, the client's side of it. What happened? What brings you here? What is causing you the most concern? What would you like to see come of this, if anything? That sort of thing. And we go through that, and then sometimes that's good because it gives them a chance to tell their story, which I like to hear. I want to understand it from their perspective, and not just what I have on paper. And occasionally they'll say something that we didn't catch the first time. Maybe Jen missed something on the note, or maybe it was said differently. And so it gives us a chance to really flesh that out and see, really what we have going on. And once we've done that, I kind of explain what we're going to do at that point throughout the meeting, what we've done in the past. if this is the type of situation we can help with, which it almost always is. And then we start to talk about different options. We kind of narrow down the scope of what it is we can do. Usually there's 3 or 4 different options. Most of the time, not always though, it ends up as some type of a bankruptcy case. I mean, and again, I think that's when people call us, that's usually what they're looking to do. Not always though, and that's okay, because there are times, many times, when we get into that room and we go through and dissect everything. It turns out that filing bankruptcy may not be the best thing, or maybe there's a better option. Sometimes it's wise to file bankruptcy, but maybe we should wait 3 months or 6 months or a year. And then sometimes it's like, we got to file this right now. Okay, so again, everybody's circumstances and situations are different. And that's why I have Jennifer get all that information together, because a lot of the stuff that my client really isn't thinking about as important or relevant really is, in terms of ownership of assets and when they've paid certain debts. And there's a whole lot of other things that are really, really relevant that you just probably wouldn't think really matter if you don't know what you're doing. So we get to the bottom of it. We go through all the options, and then we try and narrow our focus. And if someone can say, yes, I want to do this, then we can start the process at that time. I mean, if someone wants to say, well, I want to think about it for a day or two, hey, there's no problem with that. I want to go talk to my mom, my spouse, my girlfriend, my boyfriend, whoever your confidant is, if provided they're not there already. I mean, please feel free to do that. I want you to be comfortable. I want you to go into this. But what I don't like is when people just put it off, because it just bothers me when someone comes in to see me. We go through all this, and then they don't do anything, and then they call me 6 months later, having their wages garnished for the last 3 or 4 weeks. They've lost all this money. It was just unnecessary. But it does happen, and I understand. I mean, it's a big step, and part of what I try to do when we're meeting is to just create a comfort zone, so that people realize how important it is, but also how much it's really, they've made it up a lot bigger and badder in their minds than it really is. The process itself doesn't have to be complicated. And if we just kind of follow along with this protocol, it won't be.
Well, what I think is great about your process is that you have it planned ahead of time, and you're really able to tell people the pros and the cons of each solution. So they will probably know, when they leave your office, if they don't make a decision, that, it is possible that their wages will be garnished. And so when they come in 6 months, if they hadn't made the decision, you can both look at each other like, well, this is what I said was going to happen. And you're like, yep. And not that you would say, I told you so, but I mean, it's not going to be a surprise to them, because you've seen this, as you said, for over 20 years, you and the rest of the partners. It is just, it's a cause and effect kind of situation, and you can give people the heads up. If they've never been through this before, and this is the first time they're hearing the information, they have someone on their side that has 2 decades worth of experience. And so I think that that's what's important. Now, let's say that they, go through all of this and they decide to hire you. I know that, there's a couple types of bankruptcies. What happens if they hire you for a Chapter 7 bankruptcy?
Okay. Well, and before we do that, I just want to be clear. I will never tell someone I told them so. A lot of times when that situation that you mentioned happens, and it does happen, they come in saying, you told me so, and I should have listened. But I wouldn't do that to somebody. And we're not going to file if the pros don't outweigh the cons to doing this. We're not going to do it. I mean, if it's going to create more pain than it is help, we're going to find something else. But yeah, if someone comes in and we go through the options and we land on Chapter 7 bankruptcy, what happens next? Well, let's talk about what Chapter 7 is first, okay? So when you file Chapter 7, what you're doing is you're asking the bankruptcy court to just eliminate certain debts. Okay, the word we use is discharge, to discharge certain debts. Debts like credit cards, personal bank loans, payday advance loans, online loans, money owed on cars that have been repoed, or leases that were turned in early, money owed on foreclosed homes, or through landlord-tenant eviction actions, old utilities, things like that. Those are old cell phone bills. Those are generally the most common dischargeable debts we see. Sometimes IRS income taxes can be discharged if they're a certain number of years old and certain circumstances are present. And then the things that just to get this out of the way, there are certain debts that we can almost never discharge. The big one is, unfortunately, student loans. And the day that changes will make me happy, as well as a lot of other people out there, I'm sure. But alimony, child support obligations, we can't discharge in bankruptcy. Court fines, like traffic tickets, things like that, don't go away. Unemployment overpayment, that's another big one that we no longer can get rid of. And that's a tough one because they're pretty tough with overpayment penalties. They can be a nightmare. But there are solutions for that too. But so there are certain debts we can't get rid of. But to answer your question, once we've gone through the process and figured out, okay, this is a scenario that's very ripe for Chapter 7, what happens next? Okay, well, obviously we talk about the costs of filing and how that works. We generally don't quote prices on Chapter 7 cases until we've done this analysis, because I found historically when I do that, like if someone calls, and I used to do this years ago, and a lot of law firms still do, and I learned the hard way, and I'm not sure what they're waiting for, but if someone calls me and says, hey, how much for a Chapter 7? I mean, to me, that's almost like calling a car dealership and saying how much to buy a car. I mean, you don't know there are so many different, just different things that can be done in Chapter 7 and different levels of complexity in Chapter 7 cases. I can't quote a price like that until I know more information, because I wind up either overquoting or underquoting, and it's not fair to anybody. And then we start off on the wrong foot, and it's just not a good scenario. It's the beginning of a bad relationship, in my opinion. I don't want people to think when they call me that I'm all about the money first too. I don't want to talk about money until I've created enough value for you to think that my services are worth paying money. Because you may come in here after having been quoted a price over the phone, and you meet with me for 20 minutes, and what if you don't like what I have to say? What if you think I'm not offering any value? Now I got this number out there that really doesn't mean anything. So I want you to understand what it is we can do. I want to be able to show you what we can do. And then only then, if you decide that that's a great idea, we then talk about money. Rest assured, we will make it affordable. And what I mean by that is we offer a number of different payment plans and things like that. I can almost always make it fit. I can almost always make it work. And we can usually file a case for very little money down too. So that's a good thing. So I want to focus more on the service and more on the result than I do on the money, because that's really what you're after, okay? So, but once we've talked about the money and the different payment plans, then we've got that out of the way. Now it's time to talk about what my responsibilities are going to be and what your responsibilities are going to be. I guarantee that I'm going to do everything I can to get you this discharge, to get rid of this debt. I'm going to prepare all the paperwork. I'm going to file it with the court. We're going to file amendments as necessary. We're going to return your phone calls or answer your phone calls when you call. Respond to your emails and texts right away. There's always going to be somebody available to talk to when you call, so that if you have an emergency, in your mind, if it's an emergency in our mind. I want you to be able to reach out to us when you can. So those are the types of things we're going to do. We're going to see your case through to not only discharge, but we're also going to see you into a credit rebuilding program to bring your credit score up to at least 720. So we're going to be with you for a while on this. But I also want to make clear at these meetings, what my client's responsibilities are, because it's important to remember that this is now I'm talking to my client. This is your bankruptcy case, okay? If you don't do the things that are necessary to help me see this through, it's not going to hurt me. It's going to hurt you, and I don't want that to happen. So I want to be clear as to what it is I need you to do. And I'm only going to ask you to do the things that I can't do, which really only amounts to providing me information and certain documents. Okay? I can't read your mind, so I need you to tell me things, obviously. And I don't have access to your personal paperwork and documents unless you either provide them to me or give me access to them. And what I mean by that is there's a relatively short list of documents we need in Chapter 7 cases, which ranges from a couple of tax returns to some pay stubs, possibly car titles, things like that. If you own a home, we need recorded deeds and recorded mortgages, but I can usually get those on the county website. So if you're in one of the counties where I can do that, I always volunteer to do that, just because it's probably easier for me to do it than it is for me to explain it. So I go ahead and do that part of it. But just some bank statements is another one. I'll need copies of bank statements. It's all stuff that you either have or you have easy access to for the most part. So it's not really very complicated on my client's end. But those are things I have to have, and I have to have them in a fairly short period of time. Otherwise, we get delayed, and sometimes the case moves on and doesn't get discharged on time. We don't want that to happen. So when we ask for when we ask for documents, we want them as soon as humanly possible, just so there's no delay in getting the results that the client wants. And then the other thing that a client has to do, and this is regardless of what type of personal bankruptcy they have to file, they have to do a credit counseling certificate. And that's real easy too. I just give them a website and a telephone number, so they could do this either over the phone or online if they prefer. And it's just a series of questions they have to answer, and I think they have to pay like $15 for this certificate that they get, which I have to file with the bankruptcy case. That's just a federal law that requires them to go through this, or jump through this hoop before they can actually file the case. It's by no means complicated, but it's just something that has to be done. And that's really about it. And then moving forward, once we have those documents, I can typically put a case together within anywhere from 1 to 3 days is my turnaround time typically, once I have everything. So it doesn't take a terribly long time. I will generally focus on filing cases where I have some kind of urgent creditor action on the other end going on, like a garnishment in place. If I have those types of cases, I usually try and get those done first because they're very time sensitive, but that usually doesn't slow up the other cases. Again, if I tell you a day or 3 days, that's about where we're going to be. And then once I've prepared the documents and prepared the paperwork and we have all the documents, then we arrange a signing where you get to go through the documents with me, and we just verify that all the information we list is accurate, true, and complete. We've got all your assets listed, all your creditors listed, all of your sources of income and your expenses, and all your financial information in place and in order. You'll sign off on it, and then we can file the case electronically, which means we can file it from here. All cases filed in federal court now are filed electronically, which is a big plus. This has been the case for about 15 years in our district here. It used to be that we'd have to take these cases, these files are probably 70 pages long, and we'd have to copy it 4 times and take this big packet of paper down and file it in the court. And we'd have if I'm filing 10 of these at once, I've got 2 suitcases full of paper. We don't do that anymore. We go online, hook right into the bankruptcy clerk's site, and it just gets filed that way right into the court system. So we instantly get a case number, which speeds up the process in stopping the creditors too, because if I can just go online, file the case, get the case number right away, I can then contact the creditors who are harassing you or the ones that are garnishing you. We can get them stopped a lot quicker than we used to be able to do. So that's a big plus, is just being able to do it so fast. So that's from the minute you walk in to getting your case filed, that's what it entails. And if you want me to go forward, then we can talk about what happens next.
I would love to talk about what happens if they file a Chapter 13. How is that different than your usual Chapter 7, which I know that most bankruptcy firms have more Chapter 7s, but a Chapter 13 is sometimes necessary and, in fact, recommended depending on the circumstance.
Yeah, so typically a Chapter 13 is filed. There's a few scenarios. I mean, most of the time when I see someone who's got, the debts that we talked about getting rid of earlier, the credit card debt or the old repossessed vehicle debt, things like that, ideally we'd like to file a Chapter 7 to just get rid of it. But maybe there are times when we can't. Maybe the person had filed a bankruptcy less than 8 years ago. Well, then we can't do a Chapter 7. Or maybe they don't qualify for a Chapter 7 because they're earning too much money. Or maybe they have too many assets that we can't protect. Those are just a few of the reasons that we want to avoid Chapter 7 and maybe look at filing Chapter 13. And a Chapter 13 is just a reorganization of debt where we're not necessarily getting rid of all of it. In most cases, we're getting rid of most of it. And the debt we are paying back, we get to pay back at no interest over a much longer timeline at a much easier pace. So it really regulates how you're paying the creditors back. Like, just a quick example, if you've got credit cards, let's just say your monthly minimums are $1,500 and you're drowning with that. If you're not eligible for Chapter 7, maybe we can do a Chapter 13 and you're paying back $500 or $600 a month versus $1,500. And at the end of the Chapter 13, you're only paying maybe 20-25% of the total amount owed. You're getting rid of the rest of it. So it saves you money in the short term and the long term. If we do a Chapter 13, the document list we need is a lot shorter. Really, all we need in Chapter 13 cases are your last 2 tax returns and 6 months of pay stubs. And that's really it. Now, occasionally, the court or the trustee will ask us for a few more things, but generally they don't. That's usually all we need in terms of documents. And then, of course, that mandatory credit counseling course I told you about, where they have to pay the $15 and get the little notice thing. That has to be done in all bankruptcy cases.
Wow. I mean, so it doesn't sound like it's too difficult of a process. You guys are able to walk people through the process, make sure everything gets done correctly, and pretty much it sounds like things happen fast as long as you get the documentation that you need. So I wonder, I mean, you've given us so much information today, but I just wonder if you could tell us a little bit about what kind of meetings can they expect, and are they very stressful? And just describe, what happens after the paperwork is filed with the courts, and what happens there.
Yeah, sure. And that's going to depend on whether it's a Chapter 7 or Chapter 13. So I'll walk you through both. And also, but it's worth mentioning, I just rattled off a bunch of information there. And this is stuff I know. This is what I do for a living. I'm not going to just tell you to do all this and expect you to do it. I'm going to break it down, give you something in writing, show you exactly what we need, walk you through it, call you in a couple days. After you provide some of the documents, but not all of it, call you, follow up, tell you we still need A, B, and C. And we're right there on top of it. So you don't, at no time are you going to have to remember any of this. The purpose here is just to put the information out, but you're never going to have to remember all this. That's our job. We'll take care of that part. Okay. If a person files a Chapter 7 case, though, they're not even going to see a judge in 99.9% of the cases. We're going to file the case. There's going to be a meeting scheduled about 30 days later with a trustee. Now, the trustee is not a judge, and that's important to remember. The trustee meetings aren't in the courtroom. They're in a much smaller little room. And the trustee's job isn't to adjudicate the case. Their job is to just go over the documents with us to make sure that all the information we provided was accurate, to make sure that no amendments are necessary, and just to look to see that there are no assets that can be liquidated. So that's really all they're doing. Those meetings in Chapter 7 cases, and they're called the 341 creditor meeting or meeting of creditors. But usually it's just me, my client, and the trustee. Occasionally a creditor will come in to ask a couple questions. Usually it's only if it's like a credit union type creditor. They'll come in, if they want, if you've got a car that's financed through a credit union, they might come in and ask you if you're planning on keeping the car and you're still making the payments, or if you want to give the car back. That's about the extent to which the creditors get involved anymore. But that's the only meeting we have to go to. And those meetings typically take anywhere from 2 to 5 minutes. I mean, you're in there, you state your name, your address, you verify your signature on the documents, you verify that the document or that the paperwork we provided was truthful and accurate and complete. And then you just answer any other additional questions the trustee may have. And I always tell my clients, I meet with them before we do these meetings and just assure them, look, all you have to do is go in there and answer the questions and just do it as truthfully as you can. If you don't know the answer to a question, then say you don't know. If you know the answer, but you can answer it with a yes or a no, always use a yes or a no. The trustee will ask you for more information if they want it. I know some people want to explain themselves and explain the situation, and that's fine. I know where that's coming from, but it's not always a good idea. Sometimes it creates confusion. Sometimes it just gets the trustee curious about other things, and then we go on this wild goose chase and it's not necessary. So I really will coach my clients before we go in there, just saying, this is exactly what's going to happen. This is how you're going to take. I'm not telling them how to answer. I'm just telling them this is how the types of answers you're going to give. You're going to give very specific answers when you can, and don't try and guess if you don't know the answer. And that's perfectly fine. As long as they're truthful, everything goes just as I tell them it will. And that's really it. In a Chapter 7 case, once you've done that meeting, you're basically done. Now, your case doesn't end that day. It's usually about 60 days or so before we get the discharge being the order from the court that officially eliminates all the debts, all right? But as far as what you have to do as a bankruptcy client of mine, you're basically done at that point, unless I call you up and say, hey, the trustee called me and they wanted a couple more pay stubs or another bank statement or whatever the other document might be. Occasionally that will happen, not usually, but that's really it. You just have to provide the information to us, and then you've done everything you have to do. Then we get the discharge in 60 days, and then we start the good part, rebuilding your credit score.
Wow, so that's really great. It sounds like you can get some of these cases through in 6 months or less. Would that be correct?
Yeah, generally about 3.5 to 4 months is about what it takes from start to finish.
Well, that's really good news. So I love that we're able to talk about this process. Now, I know that getting your credit back, that's another whole story, but that is something that you help out with. And you said that there's a few segments to what you do. We've gone over a couple of things here in this interview. What can we look forward to for information in the future? And I know that that'll have, more to do with how to rebuild your credit and, what you should do in the future financially, those kinds of things.
Yeah, well, what I tell everyone is, our attorney-client relationship only lasts for, about 6 months or so. But that doesn't mean that I don't want to hear from you. I expect to. That's the language I use too. When I meet with a client, I expect them to call me if they have a question or a comment or a concern or whatever. If it's somehow even remotely related to what we're doing or what we did, I want to hear back from them. One common one I get is I'll get calls from clients who have been done with their bankruptcy for 6 months, 2 years, whatever. And they'll say, hey, listen, I just got a call from a creditor. They want money, and I told them I filed bankruptcy, and they said they didn't know anything about it. And I'll say, okay, so I'll look up the case, and I'll pull the list of creditors, and I'll see, okay, well, they're not listed on there, so it would make sense that they didn't know the bankruptcy happened. Well, in that case, what I need them to do is the client just needs to provide me the information so I can contact the creditor and let them know, look, we filed bankruptcy back in March, we got a discharge in June, we're done here. And there's certain documents I can provide, and that makes it go away. And usually when I tell a client this, that really puts their mind at ease, because then they're not under as much pressure. That I can do this going as far back as you want. As long as the debt existed before we filed the bankruptcy and it's a dischargeable type of debt, then the bankruptcy will have that discharge effect on it. It's just that if the creditor didn't get listed in the documents, they're not going to know that the person ever filed. So I can't really fault them for calling. But once we notify the creditor that the case was filed, at that point now we're really careful, because if that creditor starts to call again and again, now they're violating the discharge order, and that's a whole nother story, but we can go after them for that. So they generally don't do that. When they hear from us and they hear the word bankruptcy, that's usually where they put the brakes on for good.
Wow, that's really great. And I can see where that would put your clients' mind at ease, because they've been, usually by the time they get to you, they've been under stress for a very long time, sometimes years, and it's taken them a long time and a lot of consideration to make this decision. But it is, in the long run, for those people that it's right for, it's a huge stress reliever once it's over, and their life really can begin. And I'm sure, and before we go, you don't have to get into too many details, but do you hear a lot of wonderful success stories after a bankruptcy is completed, once people have had time to repair their credit?
Yeah, I do. I almost don't hear anything but success stories. All right, we all the time. I mean, I tell them what's going to happen, but people are hesitant to believe it till it really does happen. And if you follow the steps, if you do the things you're supposed to do in a timely fashion, you enhance and increase the likelihood of success. So if we get a case file and get through it, get the discharge, and then we go through the credit rebuilding steps. And that's really important because there are some steps you have to take. And again, maybe that's for another interview, but if those things are done and done properly, there's nothing complicated about it. There's nothing difficult about the steps, what I'm asking them to do. It can all be done in a fairly short period of time. It's just a matter of committing to it and following through. And look, I'm going to get you a discharge, okay? And if I can't, I'm going to know that before we file. So we're going to weed that out before we even get into it. So that enables me to create a guarantee for clients that I'm going to get you from A to Z. As long as what you're telling me here is accurate, I can tell you exactly where we're going to go, how long it's going to take to get there, and how it's going to feel at the end. But there are steps that you have to help me take, that you have to take with me. And if you don't take those with me, yeah, you'll still have success, but you won't maximize on the success. But all the time I have clients call me. We get really good reviews. I just had a few things I think I was telling you before we started the interview about that were posted on Facebook just yesterday about how happy people were with what we've done for them. And I love to hear that. And I also love to hear if someone thinks that we didn't do a great job too, because I mean, there's always room for improvement, even if they're nitpicking, that's okay. I always want to make the client experience, the second most important thing. Obviously the first most important thing is the result, but I want the client experience to be, as good as it possibly can. So we have all kinds of success stories. It comes out like this. You file the bankruptcy, you protect yourself, you're no longer subject to garnishments and collection calls and all that. You get a discharge, and generally in about a year and a half, your credit score is probably into the low to mid 700s. And I don't care where you start. If you started at 450 or 500, doesn't matter. You can get there. It's not that hard to do if we follow the steps, do them in a timely fashion, and just dot our I's and cross our T's. That's all we got to do. Just follow along with me and we'll get you there. I guarantee that.
Well, I think this is fantastic. And, I really want to thank you for doing what you do, because it makes a huge difference in people's lives. I mean, you're saving their financial future. You're saving, I'm sure, a few marriages. And I mean, there's a lot of things that, having a fresh start can do for your life. And, even the physical ailments that people get from being under stress for so long, a lot of times will go away once they're able to sleep again, and once they're able to, just relax and enjoy life again. Because, when you're under all that stress for so long, it really does build up on you in so many different ways. So it's nice to see how you and your law firm are able to affect these families and individuals in a positive way and help people get on with their lives. And so you only live once, so you want to make sure you're doing the most you can to have a good one. And so I think with the way that you act with people and how your demeanor is so friendly and understanding and empathetic, gauged, along with your intelligence and knowing what to do and how to get the job done, I think it all works so well together. I would absolutely recommend, if you or any of your family members or friends or colleagues have questions about what they should do financially if they're feeling burdened, just have a meeting and ask some questions. You don't have to commit to anything, and the first meeting is free. So knowledge is power, and you might as well get it.
I couldn't agree more. Don't delay. I mean, you've got a life to live out there, and why have unnecessary stress and pressures, bring you down? Move on. Thanks for the kind words, Eric. I appreciate it.
Oh, you're welcome. I believe every one of those. I know that really make a big difference. So I can highly recommend it. Thank you so much again for talking to us today, Tim. We are looking forward to some really great interviews in the future. I know we've talked about some exciting topics, so I hope everyone will stay tuned and listen in for those. And I hope everyone has a really great week.
Yes. Have a great week. Thank you so much, Erica. I'll talk to you soon.
Thank you.